A very good afternoon to all the participants. Today, we have amongst us our Honorable Chairman of Indian Academy Education Trust, Dr. T. Somsekhar, Mrs. Bharati T., Madam Secretary, Indian Academy Education Trust, Dr. Srinidhi K. Parthasarathi, Chief Operating Officer, Indian Academy Group of Institutions, and our beloved Principal, Dr. E. Jerome Xavier. My wholehearted welcome to all of you. My special mention of welcome also goes to my fellow colleagues, participants from India and abroad, and my dear students too. Intellectual property is a category of property that includes intangible creations of the human intellect, and the need to protect it is a real necessity. In the present context, innovative intents are hijacked, which never see the light of the day. If inventions evolve from innovations, then innovations cease to happen if inventions are not protected. Intellectual property is a thought by one's mind. Certain creations of mind are recognized as special creations, and they can be protected through law. Today, we have the resource person, Dr. Togapur Pawan Kumar, Senior Scientist, CSIR Institute of Minerals and Materials Technology, Bhubaneswar, Odisha, amongst us to enlighten us on the insights of intellectual property rights. May I now request our principal to address the participants.
The honorable resource person for the day, members of the faculty, and my dear students. It is an honor to have such an outstanding person, particularly in the field of intellectual property rights, who is also a scientist, which indicates that he has not only personal experience, but personal commitment and involvement. Nice to have such an eminent personality to share his wisdom and knowledge with all of us this afternoon. On behalf of the Indian Academy Degree College Autonomous, I am extremely grateful to the resource person, and I hope we, the teaching fraternity, will be happy to not only listen to his talk, but draw inspiration, knowledge, and put it in practice, particularly in the field of research and publications. Thank you very much.
Thank you, sir. Thank you, sir, for those insightful words. It's a pleasure introducing Dr. Togapur Pawan Kumar on this occasion. Dr. Pawan Kumar has obtained his PhD from CSIR, Indian Institute of Chemical Technology, Hyderabad, and went on to complete his diploma in patents law from National Academy of Legal Studies and Research, Hyderabad. He further pursued 7 courses in intellectual property rights and management from WIPO Academy and Allison's Academy. 2 of them who are considered to be the stalwarts in the intellectual property rights education. He has been quite actively involved in research and has established his acumen in research through or by receiving 12 research projects granted to him. He has been actively involved in various things. In fact, I was taken aback when I looked into his biodata, curriculum vitae. It went on for more than 15, 16 pages. I was just stunned looking at his accomplishments. But just to sum up a few of them, he has received 12 projects from various funding agencies in the capacity of a co-PI and PI. He has been granted 3 US patents, 1 European patent, 1 Indian patent, and 17 of them are under processing to be granted. 23 awards and recognitions being bestowed upon him right from the district, state, national, and international levels speaks volumes of his wisdom in his area of interest. Dr. Pavan has published more than 21 research articles, both in national and international peer-reviewed journals. Sir is a member, a lifetime and active member of many agencies. To name a few, he is an Associate Fellow of Andhra Pradesh Academy of Sciences, Life Member, Chemical Research Society of India, Inspire Faculty, Department of Science and Technology, DST, Fast Track Scientist, Science and Engineering Research Board, Life Member, Material Research Society of India, Life Member, Indian Society of Chemists and Biologists, Life Member, Indian Science Congress, Member of Global Intellectual Property Convention, Professional Member of Institute for Engineering Research and Publication, to name a few. He has been a resource person in more than 35 conferences, workshops, presentations, and technical. He has also, participated, and he has as well been a resource person in more than a handful of occasions where he has enlightened thousands of young minds like us. Dear Dr. Pavan Kumar, we are really privileged to have you amongst us this afternoon to enlighten the participants. Dr. Pavan Kumar, the session is yours.
Yeah. Thank you, Dr. Rajarajan, for your nice introduction. I think meanwhile, I'll be just sharing the screen. One second. Is my screen visible?
Yes, sir.
Okay, I'll make it PowerPoint mode. Okay. So good afternoon to all. First of all, I'm very happy to be part of this national webinar. And also, I thank all the organizers, especially Dr. Shiba, for taking the efforts in inviting me to this webinar as a resource person. And I also congratulate all the college and the team. This slide is for you all, for the participants, for the organizers, as well as for the college, in taking initiations towards having these kind of activities. Because nowadays in India, there is a huge demand, or there's a huge gap for doing research and the research output. So therefore, there are many people who are pursuing research. But however, when we talk about research outputs, there's a big gap. We only cherish with publications. But however, we are still wondering about how to contribute effectively towards the development of products or innovative solutions. So therefore, today's title of presentation is Research Ideas to Development and Patenting, an academic perspective with case studies. If you look at the title, you may wonder, why did I put patenting in red? Because that is a very, very essential activity, which is a very much required activity. But however, we feel it is something different. So therefore, I have tried to choose the colors in such a manner that the color or the presenting format itself will reflect the inner meaning. And this is the layout of my presentation. I'll be talking about some important issues of intellectual property rights, what are called IP, or what are the different types of IPs, just to make you a recap of the IP concepts. Then we'll talk something on ideas and creativity. How does these creative ideas can be converted into innovative ideas or inventions? Then we go on to the research developments and further taking them to patenting aspects. Then we will talk about patent processing with some characteristics and statistics and the processes and agencies which will help academic sector or the research sector in taking up their research activities to patenting outcomes. And we end up with some takeaway messages. So therefore, let us start with our first module, intellectual property, a very quick overview. I think this definition you all might be knowing. This is given by World Intellectual Property Organization. IP refers to creations of the mind. So therefore, human being is involved in this. Inventions, literary and artistic works, symbols, names, images, and designs that are used in commerce. So here, when the term commerce comes, it has something related to economy, something related to business, something related to money making. So therefore, IP always has relation with money making. So therefore, coming up with inventions or generating ideas, leading them to IPs, and then converting them to useful outcomes for profit making is a very, very important aspect of intellectual property. Now, this is a comparison between a tangible property and an intangible form of property, which is also called as intellectual property. Like we have other properties, we also can have intellectual property. And if you compare both of them, almost all we get all sorts of advantages. But however, the major difference between IP and other forms of property is the limited period of enjoyment and territory bound. So these two are the major differences. As a IP, it can play major role in many of the activities. It can be sold, it can be bought, it can be leased or rented, it can pass under a will, it can be assigned to someone else, whoever you wish. But however, it is also useful in bringing economic rights to the creators, can be used for a commercial exploitation, it can be used for making capital expenditure, technology transfer. Overall, it can be used for cultural development of a country or of a state or of a organization. So therefore, in short, creation of human mind is called as intellect, and the rights derived from these are called as intellectual property rights. These are the exclusive rights given by the statutes, but however, always attended with some limitations and exceptions. And always these are time bound and territorial bound. This is about types of intellectual property rights. Very briefly, I tried to categorize them in two basic aspects. One is industrial property, the other one is copyright. So when it comes to industrial property, it has again divided into two types based on information and based on innovation. And most of our research activities or academic research activities will fall under the category of innovation under industrial property rights, which consists of patents, trade secrets, and industrial designs. On the left-hand side, I had shown you all these types of intellectual property rights with an example each. Like Coca-Cola, formula of Coca-Cola is a trade secret. Harry Potter is a copyright. Darjeeling tea is a geographical indication. Look into this. So when we talk about IP, we might be hearing many aspects. Some people say it is very easy. Some people say it is very difficult. And when you look into my profile, you may feel that I'm very much expert. I have a lot of expertise in IP and converting research works into IP. Maybe that is true at this point of time. But if I go back to 10 years, then I'm almost just a simple researcher. I was not having any idea about patent. Until I completed my PhD, I did not even search for any single patent. But now You tell me any concept, I can guarantee you that I will find some or other relevant reference across the globe. So therefore, IP has taken a big jump over a period of time. But however, this slide tells you how did these different types of IPs have evolved from an idea. So idea leading to expression is a copyright. Idea leading to innovation and invention is a patent. Idea which leads to quality and identity is a trademark that has a lot of significance, that creates the brand. Idea leading to appearance is only a design. Then if you have an idea, keep it confidential. Please don't disclose it to anyone. Then it will be a trade secret. Now, look at this. A very simple object, one example of iPhone, but however, it has several IPs within itself. Why? Because the shape is protected in the form of industrial design, logo is by trademark, any improvements over technical features will be in the form of patents, and all the software and reading material or the brochures all are protected by copyright. So therefore, single object or single example can also consist of several types of IP within itself. Now, having known all these aspects, even then, when we talk about intellectual property, many things will keep on revolving in our mind. It's a law, it's a secret, licensing, invention, copyright, brand, what exactly all these are. So therefore, here we try to connect them from idea to development, then to patenting. So therefore, now we all should agree that we are in the age of invention. Whether you accept it or not, now the globe is towards bringing up new knowledge, new inventions, and new activities. So therefore, we have to contribute. And before contribution, we should know what exactly it means. Then only we can realize its importance. Then we can start contributing. And in the age of invention, here I will show you some of the very, very important inventions which have revolutionized the human community itself from the beginning of maybe 1800 years onwards or even before. Look at this example. Friction match was invented in the year 1836. Of course, at that time, we were not having independence. Our problems were totally different. But however, in US, they got a patent for this. Look at this, sewing machine got invented in 1855. I don't know, at that time in India, we were not even having one or two machines at least. But the other side of the globe, they started practicing IP in a very, very organized manner. Look at this, he's a politician, but he has invented a dishwasher. He got a patent, US patent. For all these examples, I am providing the patent numbers also. Being a politician, he was also very curious about finding solutions to the problems. So therefore, he got a patent for a dishwasher. Look at this. This is very important for Indian traffic. But however, it was invented in the year 1923. I think in that during those times in India, hardly there could be one or two traffic signals in major cities like Chennai or Delhi or somewhere. But Westerns, they have evolved very quickly. Look at this ballpoint pen. It was invented in the year 1888. Look at this. Chin rest for the dead. See, in India, we don't have value for the living human beings. Of course, anyway, we don't value animals. But even for human beings also, we don't value much. But at the other part of the globe, they have developed or invented a chin rest for the dead. So that is the kind of systematic evolution for IP aspects is very, very important. And even foreigners also have invented a artificial heart in the year 1979. Now, what leads to all these things? This is a very big question mark. But we all feel that it is idea. Is it idea itself? No. Idea added with some creativity. Then it may lead to some novel outputs. So therefore, when we talk about these aspects, a question comes into our mind. What do we mean by discovery? What do we mean by invention? And what do we mean by innovation? Then this is the answer. Discovery is something which is already existing in the nature, but however, you are the first person to disclose it to the world for the first time. Likewise, Einstein's theory of relativity and theory of gravitation by Isaac Newton or many others. So all these are discoveries. They were already there. But then what do we mean by invention? Invention is nothing but a solution to the existing problem in the field of science and technology. But it need not be essentially in the field of science and technology, in any field. So therefore, invention adds to human knowledge by suggesting an action resulting in a new product or a process. So this difference we should understand, because once we are satisfied and very much clear about these differences between a discovery and inventions, we can easily able to convert or relate our research works to the productive outcomes. Now, this question is for you all. Is this a discovery or invention? I think by looking at this picture, by now you should have understood what I am going to talk on this slide. Eureka, you might have heard about this word. So it is theory of buoyancy, Archimedes, principle of Archimedes. So therefore, it's a discovery, because whether it is Archimedes or someone else, the same would have happened, or the same thing would be happening. But it is Archimedes who has discovered it for the first time. Then look at these things, a very primitive wheel. But later on, many advancements have come. So the very first solution to the problem is called as invention. If you work on those existing solutions, and if you come up with new or improved versions of solutions, then they may be termed as innovations. And always innovations will be towards the market pull. Based on the demand in the market, the innovation will take its shape. Similarly, integrated circuits. The very first integrated circuits were referred to as inventions, but later on, many advancements have taken place. They are all called as innovations. Look at this. Internet is an invention, whereas social media, which is using this internet, is an innovation. Look at this again. Microwaves were earlier used in radar applications. That's a very well-known fact, and it is not a very new thing. It's a kind of not very age-old, but it's a kind of old practice. But however, later on, many works have converted or observed utilization of microwaves for cooking applications. So therefore, existing innovations may also lead to new innovations or new inventions. Look at this slide. These are some of the very simple inventions, but the idea in bringing out these inventions can be termed as the great ideas. She has developed a full color reflection hologram, Holy, and Annie Moore invented Snuggly Baby Carrier, and Remya Jose, look at this girl, she is from Kerala. She has invented a pedal powered washing machine, and Barbie doll was invented in 1959. All these are patented inventions. Now, idea. We all know cricket is a method of playing the game, but this was the stumps or the wickets they used to have in earlier days. But now advanced systems have come. So therefore, what is the difference? Here, an idea and followed by working on that idea led to the development of this advanced technology, for which this person has got the patent. The title of the patent is System for Indicating Movement of an Article from one position or orientation to another position or orientation. See, look at this. He did not mention anything about cricket. He did not mention anything about wicket. He did not mention anything about stumps. But he has made a very generic invention which is applicable to this, and now he has become the billionaire. You know, he has protected his invention almost all in all the countries across the globe, whether they play cricket or they don't play cricket. Even now, he has not sold his invention. Neither he has produced these wickets in bulk quantities. What he does is always he gives these wickets or stumps on rent basis. That too particular to that cricket field. So that is the power of having an idea, a powerful idea or a potential idea which can lead to a very, very strong inventive concept. And once you patent that and then start utilizing, then certainly you can bring a very big change in the technology, in the society, as well as by yourself. So therefore, when we look back into our thoughts and ideas, there is a small survey which says that our mind thinks on an average about 60,000 to 80,000 thoughts per day. That means each one of us is a born inventor. When we can generate so many thoughts per day, the only limitation is we have to identify useful thoughts out of this. Then we have to convert them into probable ideas. From there, we should take them forward for product development or workable ideas. But however, if you just have only ideas, you may be having unlimited. But if they are only at the stage of having ideas, then you will not get any patent. So patents are not given for just ideas. You have to convert your ideas into workable ideas. That is the place where research and development activity comes into place. Now, once you generate ideas, you have to also analyze if your idea is valuable or not. If you feel that your idea is valuable, then you have to own it before someone else will take away your idea. Because as I told you, everyone keeps generating ideas. If you feel that your idea is very innovative, you should try to own it. Otherwise, someone else may also get the same idea, they may own it. There are several instances of such cases across the globe which have already happened and which were taken away by others. Now, here I try to show you in a compact manner how an idea can be generated, then can be converted into invention, then patent, and then leads to more patents. Because as such, I told you, ideas you do not get any patent. But whenever, if you start thinking over that idea, start putting some efforts, then certainly you will be able to convert a just idea into a workable idea. Look at the example of Velcro. Actually, two people will be going for morning walks. The inventors of this, they usually go for morning walks, but most of the times they used to come up with the clothes which have some plant material sticking onto the clothes. On one fine day, they started thinking. Then they got an idea. Oh, why can't we build something or some material which can work in this way? So certainly the result is Velcro. So therefore, Velcro, this is the very first patent on Velcro, DE1115201. But later on, so many advancements have taken place, improvements have taken place, and so many models are available now. Similarly, the pen or the paper clip. If you go to Google and search for patents on paper clips, you can end up with some thousands of patents. So therefore, having ideas, converting them into workable ideas, then protecting them in the form of patents and working around them, leading to more inventions, and which may further give you more patents. So all these are possible, but however, we have to realize its potential. Now, let us talk about creativity. Is it that if you have idea, it is sufficient to get a patent? No. Idea has to be always added with some creativity. Otherwise, if you get some idea, if you try to search that in some available platforms, you may end up with the known ideas already long back. You may feel that maybe 10 years back itself, the same idea was already reported or already known or already practiced. So therefore, one has to have creativity. Creativity is the ability to think or come up with new ideas, designing new inventions, or producing new works of art, or solving problems in new ways. That is also a creativity. So therefore, one has to generate ideas, and then we should try to own them in the form of IPRs. Look at this. I try to show you some of the examples which I have picked them from different sources. Because when we talk about just idea or creativity, ideas or creativity, they don't have any limitation. They can be as generic as possible and as specific as possible. Both ways it is possible. So therefore, look at these things. Are these creative or not? Yes, because the person who has come up with these pictures, he might have had some idea, then he has put on some creativity. Then this is the outcome. Look at this. Idea, creativity, which have led to some developmental activity. He is a person from Chhattisgarh. Look at the ambulance, motorcycle ambulance. It's a very good idea, and he has added some creativity, and it has some utility, not some utility, it has major utility. Look at the bottom figure. In most of the metro cities, there are many flyovers. So some people started a free school under a flyover to educate the poor children. That's the idea. Then added some creativity, and they have got some output. Look at this. When Volvo invented the 3-point seat belt in 1959, they made the patent free for all competitors to use in order to save lives, because it had more value as a free life-saving tool than something to profit from. So here, Volvo, they have invented, they got an idea because there was a problem. They got an idea, they worked upon it, and then they come up with the solution also. They have patented it. But after getting the patent, they made their patent open to all for free use. Now, creativity has no limits. To be creative, we need not essentially be educated, or we need not essentially be very much aged or experienced. I asked my engineer to build a single bedroom with an attached bathroom. Some engineer may be very crazy engineer. They may have very great levels of creativity. So this is the outcome. These boys from Tamil Nadu, from government school, they have come up with these kind of toilet systems, urinal systems, for which they recently got some award also. And let us look back into our ancient culture. Some of the temples have these kind of drawings or architecture, whatever we call carvings. Look at this. We talk about modernization, but always we feel that modernization is a Western concept. No, it is not at all. Technology was there in India well before. It was there, it was practiced, but later on, due to some connectivity gap, there is no evidence of a systematic development. 3D printing, this is an example, is a 3D printing. This is hair accessories. These are the eyebrows, like cosmetics. This is the vanity bag. Look at this. They were already there. Maybe they might be in practice. But now what happened? In New India, look at this. When the client asks, why did you do that? The project manager or the people working on that, they say, moving the rock is not in our scope of work. So this is how we are working in today's generation. That is where the difference lies. That is the reason why we are unable to compete with the global technological market or global technological standard. So therefore, idea is so powerful. So powerful in the sense it is very, very powerful, because a man may die, Nations may rise and fall, but an idea lives on forever. This is an example. Steve Jobs has been awarded about 200 patents since his death. We all are surviving in India. In India, there's a population of more than 130 crores. Many people are there. We can't even find a single example like Steve Jobs. Even after his death, he got about more than 200 patents. So that is the idea. That is the reason why man may die, nations may rise and fall, but an idea will live forever. So this is all about the very overview. Now let us go into the details of patents, starting with the insights into characteristics, some statistics, and searching of patents, which are very, very essential for designing strategies to convert our research ideas into patentable outcomes. So therefore, in simple terms, one can define a patent as a contract between the government and the inventor. The government gives the inventor the right to exclude others from making, using, or selling the invention for a term of years. That is the reason why the patent document is simply called as a techno-legal document. We all are very, very strong in the technical part of this document. But when it comes to the legal part, we don't have any awareness. We need lot of support, lot of understanding so that we can effectively contribute. So as I told you, patent is a conditional grant. It's a balance of rights and obligations. It is also subject to other laws of the land, always granted to the inventor or the assignee. And this is the complete information present in any of the patent applications of any country, of any field, of any domain. The first page is always called as bibliographic data, which has some names, numbers, dates, then description, then some drawings will be there. Finally, the patent document will end up with claims. Claims are like boundary of your property or heart of our human body. So patents are claims are very, very important aspects of the patent. These are the very first pages of the patent, which are called as bibliographic data. The left side one is the PCT application. Right side one is a US patent application. The very first front pages, you can find some classification codes, dates, the names, all those details we can get. And now, what is so important about learning and understanding the concepts of intellectual property and more especially the patents? It is because of this. Because whenever we perform research activity, just performance is not enough. It has to be converted into developed products. Further, it should be capable of deployment. So therefore, if you categorize any of the research works into technology readiness levels, so this is how the graph goes. But however, you find there are many gaps. These gaps are there. To fill those gaps, IP plays a very, very important role. So therefore, to bridge the gap between IP and technology generation and utilization, learning, understanding, and contributing towards intellectual property in the form of patents is an essential activity for all the academicians and researchers. Because when we have a new idea to solve a problem, then that may lead to invention. If your invention leads to profit making, that is called innovation. You are contributing to innovation. So therefore, why should we always try or look for our traditional properties? Why can't we look for something new, which will also bring some visibility, credibility, and also some profit? So therefore, we should learn about converting our ideas to marketable ideas. This is the complete sequence of generating an idea and taking your idea to the market. There are several steps, and it needs money, time, different people, partnering with the people, collaborations, all these are required. For example, the mobile phone that you see in the market, it was not so simple to bring it to the market. It took a lot of efforts, lot of time, and work from so many people. But however, in Indian scenario, most of our research works stops at the stage of generation of ideas and taking them to the proof of concept. That is the reason why typically most technologies at R&D labs are at this stage. When R&D labs are at this stage, what would be the stage of academic institutions? They will be slightly here and there. But however, just stopping at the stage of proof of concept is not sufficient. We have to convert them into prototypes, scaling up, commercial production, then in use. So a big chain of activities are remaining. But however, we are finding it very difficult for our early stage works itself. If that is the case with us, look at the scenario at a global perspective. These are the top 5 countries filing patents all throughout the world. And the list is like this. China tops the list with 43%, US 19%, Japan 10%, Korea 6%. These are the top 4 countries, followed by European Unions and all others by 15%. But if you consider the India, we have a population equivalent to China, but our performance is not equivalent to China in terms of productivity or IP productivity. Look at this, patent performances in India. In India, foreigners are filing more patents than the Indians. But however, out of the foreigners, Qualcomm, Samsung, Huawei, Ericsson, Oppo, this is the order and the number of patents. And when we talk about Indian applicants, all IITs together, they have about 500. Chandigarh University itself is filing more than 300. TCS, CSIR, and BHEL. But of course, the numbers are good, but not very encouraging, because when we compare with our population, our productivity is very, very low. Look at these statistics. There are 200 times as many filings in Japan as in India. Per million population, Japan files 2000 patents. India files only 11 patents. Whereas China and US files about 900 patents. But we are, in population, we are equivalent to China. But contribution is too less. Too less in the sense, too less. It can be ignored also at a global level. And there's also a reason. India has a fraction of Japan's researchers. Per million population, Japan has 5,000 researchers. US and European Union has about 4,000. Even China also has got 200 researchers per million population. Whereas in India, there are only 200 researchers, about 200 researchers per million population. This is quite a concerning factor. We have to improve the numbers. But however, with this existing number itself, we are finding very difficult to survive in Indian context. So therefore, India also takes more time to grant the patents. Japan takes about 15 months, China 22 months, Europe 22 months, US 24 months, whereas India takes about 64 months. This is also one of the reasons why Indians don't think much about going for patent filings. But however, nowadays, Indian government has put so many efforts to bring down this time period. Now, to my knowledge, patents could be granted in about 48 months. But when it comes to publications, we all will be very happy, because we stand number 3 in world scientific publication contribution. But of course, China and US are again leading from the front. They are leading from the front in publications as well as in patents. But ours is only in publications. That itself reflects our way of performing R&D. These are the patent filings state-wise in India. Maharashtra has the highest, followed by Tamil Nadu, Karnataka, Delhi. But however, if you see these numbers, all these are per year, applications per year. Hardly except for 4 or 5 states, all other states are filing less than 500. If this is the case, then when do we really improve? So therefore, time has come for us to think when we have a workable idea. So therefore, we feel that we are in the phase of transition. Now, take ourselves as an example. Let us take ourselves as an example. If that person is I, you, or whoever it may be. If you have an idea, if you can make it into a workable idea, then now you have to start thinking. Generally, our age-old practice is, if you have some work, go for publication. Better to go for high impact publication, otherwise go for some publication. But no, from now onwards, we should stop just doing that. We should put some time and give some thought process. Then we should come up with some proper and very, very useful conclusion. At this stage, you'll be having different options for your workable idea. You can go for high impact publications. That is quite possible. You can also own them in the form of IPR, especially like patents, or you can put them in the form of know-how. Don't disclose, don't patent. But if you feel it is very valuable, just make it as a know-how. By making patents or know-how, you will not lose anything. You will get an added advantage. Once you file a patent, you can very well go for publication. That means for the same workable idea, you can get a patent, you can also get a publication, and for which you will get, there could be a possibility of industry approach. You can get good visibility, good credibility of your work. You can also get good publicity. All these things are possible. But however, till now, we were only looking for publications. But if we start looking at patents, it is like 1+1 offer. We get a patent, we also get a publication for the same work. And that is how one has to plan their research and development activities. So therefore, that is the reason why I am calling it as a transition phase. From there, always we should try to align all our capabilities at an institution level as well as at an individual level to make a strategic IP framework. It is like this. You have R&D, then you should disclose the work, you should plan the disclosure part, then all these research works have to be screened for their patentability, because all research work may not lead to patents. So therefore, this screening for patentability is a very, very important criteria. If you screen them for the patentability and if you find them, they are eligible, then better, always better and better to go for filing a patent. Go for filing a patent. If it is an engineering work, you can also file a design. In addition to the patent, you can file a patent as well as a design. After filing the patent, you go for publication. You can publish it in any of your interested journal. If you adopt this path, you will get a patent, you will get a publication, and you can use your work for commercial exploitation, by which you will get visibility as well as credibility. But if you adopt only the publication pathway, screen for patentability, but don't bother about the result. Whether you wish or don't wish, you may directly go for publication. In that case, you may get some visibility and credibility, but no other major benefits will be available. If you adopt the patenting pathway, you get like a double benefit. It is like 1+1 offer. And if you are really successful, it will be like a very, very huge difference that you make in the society as well as at your organization. So therefore, patenting activities plays key role in all functional stages of research and development activities. And always it is better to screen the research works for patentability before publication in scientific journals. Because again, patents serves as 80% sources for technical inventions. There are more than 150 million patents in the world as of now. About 400,000 new inventions were added every year. All these patents are the documents without copyright. They are available for free. You can search them, you can use them, provided if their validity is completed. If you look at the statistics, for every 30 seconds, there is a new patent document added to the vast existing library. And for every week, more than 10,000 new patents were added. When such kind of rigorous activity or contribution is taking place, then why don't we think of contributing for the same? The time has come. We have to think. So therefore, if you really feel that you have an idea, then one has to access the patent documents for the prior art, then they have to confirm that their idea is novel. So therefore, idea leading to development and patenting is a very, very systematic activity. It has chain of activities to be performed. Whenever you generate an idea, you have to assess yourself. Is your idea really valuable or not? If you feel your idea is very valuable, then what are the close prior arts that are existing? And have you disclosed your invention anywhere? Did you discuss it with someone? Did you show it somewhere in the form of a poster? Or are there any co-inventors? Is it your own idea or a group of people have conceived this idea? What are all the key features of your novel idea? Then based on this, you can confirm that your idea is really novel and it can be taken forward for invention protection. But however, you all should remember that in India, there are some inventions, though they are very new, they are having very high value, even then they are not patentable because of Indian patent statutes. They are like this: inventions which are frivolous, which are obvious, which are contrary to laws, which are mere discovery or a mere discovery of a new property or a theory, the inventions that are contrary to morality, which are injurious to public health, the inventions of the substances which are obtained by just mixing them together, just arrangement or rearrangement, or any methods of agriculture or horticulture, or the inventions relating to atomic energy. All these inventions, though they are potential, they are of high value, even then they cannot be patentable as per Indian Patent Act or patent laws. But when you feel that you have a potential invention, you should also concentrate on the claims. What do you want to claim from your invention? As I told you, claim is nothing but a boundary of your property. Like yellow one, this is the boundary. So you have to be very, very careful. This is your invention, this is the boundary. If your boundary is strong, then only your invention will be strong. So therefore, claims have to be very, very strong. The drafting of claims is an art. It has a very, very special, it needs a very, very specialized skill. So therefore, patents are very, very important because invention is defined by the claims. Whatever you write in description and here and there, it doesn't matter. Whatever is present in the claims, it matters a lot when we call it as an invention, protected invention or a patented invention. So therefore, invention is defined by the claims. Claims are tested before granting by the examiner, and these are the claims which gives legal or exclusive rights to the inventor or a patent holder. But what are the different types of claims? Because there are several subject domains: chemistry, biology, physics, mathematics, others. So therefore, all these types of claims are possible. Product claims, process claims, Marquis claims are very important for the chemistry people. Gibson claims, Swiss claims. Swiss claims are nothing but second medical use claims. So all these types of claims are possible in filing a patent application. But however, in India, all claims are not allowed. That means second use claims are not allowed in India. That is the reason why COVID treatment, repurposing of the drugs, whatever we are hearing here, we are listening in recent days, cannot be patentable in India because repurposing is nothing but reuse or second use or further use. Further use of any existing drug molecule cannot be patentable in India. In India, product claims are allowed, process claims are allowed, composition claims are allowed, method of treatment is not allowed, new physical forms with enhanced efficacy is allowed, whereas living organisms are not allowed except for the microorganisms. But when you have your work, you also have to test your work for patentability. It must be novel. It must also be non-obvious. That means it should have some inventive step and it should have some utility. And then it should also be governed by statutes of the nation. That means whatever examples I have showed you, which claims are allowed, which claims are not allowed. Only allowable claims if your invention falls under the category of allowed claims in India, then only it can be patentable. Otherwise, it cannot be patentable. Now, I heard like many people say that, sir, like my work is very good, but however, I am not finding some good industry partner who can take my work. They are not realizing the potential of my work. Then why do they realize? If you realize your work potential, then it is your duty to take it forward. So therefore, success of an invention depends on various factors. The patentable space that you have identified for your work. So the space must be very much clear, and the type of claims that you draft and the way you represent your claims is also very, very important. Look at this glass, up to half full, half empty, and the third one. But most of the time, many of us, either we fall in the category of optimist or pessimist. The glass is half full or the glass is half empty. But for a patent specialist, they describe the same glass as liquid water bisecting an open cylindrical vessel. So therefore, it is not that having invention itself make you unique or gives you some protection. No, it is not like that. Once you have your invention means you should draft your claims in a very, very proper manner. So that no other person can infringe on your work, or no other person can copy on your work, and no other person can find some scope from your work. So that is how invention can become a successful invention, provided if you can able to identify a proper patentable space and if you draft your claims in a very, very organized manner. But even in spite of all these things, there are many inventions which are under the failed category because of technology issues, market factors, and IP challenges. But only those inventions which are having all these three parameters in balance can lead to success. Now, again, look at this. When we have an idea, we know that we have to arrive to a workable idea. Then we should judge whether it is a patentable invention or not. Then how do we ascertain that my idea or my work which I have completed or which I am planning to start can have patentable value? It is all possible only by performing a exhaustive patent search. But however, patent search is not a simple activity. It's a very challenging task. It is like searching in jungle. Why? Because prior art is global. Patent rights are territorial. Similarly, science is global, technology is local. So therefore, one has to perform a proper patent search before starting working on your idea. Why? Because you have an idea. If you start working on that one, you have completed your work. Now you are planning to go for a patent. When you started performing searches, patent searches, you realize that 10 years back, the identical work or similar work is already patented. Then all the efforts that you put for generating idea, working on that idea, and then realizing that that idea is already existing, it is of no use at all. It is like putting all your chemicals and everything into the sink. So therefore, it is always better to conduct a patentability search before execution of your research work. Come up with some ideas, make a plan, then perform the search. If you feel that no prior art is existing, or if you can make a difference from the existing prior art, then you can go for working on that idea, convert it into an invention, then go for filing a patent application. That is where patent search plays an important role. For patent search, there are several databases available, but many feels that patent searching is again a very expensive activity. No, it is not like that. There are many free patent databases available which can also give you very good search results, such as WIPO Patent Scope and eSpaceNet USPTO for country-specific databases, USPTO, EPO, Japanese patent database, even Indian patent database is there. Any country-specific database will give you information, patent information of those countries. But however, if you go for WIPO Patent Scope or eSpaceNet or Google Patents, these databases will give you information on patents from different countries. Of course, apart from this, there are many paid databases also. And you can also perform a keyword-based search, class code-based search. These two are very, very important. Keywords anyone can understand, but what do you mean by class code search? If you look at the first page of the patent document carefully, you will find several codes, IPC codes, International Patent Classification Code. Each code has a definition for the technology domain. If you can identify a code of your relevant technology domain, you can very easily retrieve all the patents to your technology, related to your technology. That's a very, very easy aspect. Here I try to show you this search activity and converting your ideas, then assessing them for patentability, and then converting into patents. The preliminary steps are searching for patentability or criteria for patentability assessment, for which, first of all, you have to start with the idea, take that, find out some keywords, key elements which defines your idea, then try to perform a very preliminary search by using any of these databases, then identify some very relevant patents. From there, try to take out the relevant class codes, any additional keywords or specific terminology that they mention, all those you take out, then refine your search strategies, then perform a complete, exhaustive or comprehensive search. Then from there, from available results, you categorize them, which are relevant to you, which are not relevant to you. From the relevant documents, you try to identify what exactly they are talking about, in what way your idea or your concept is different from the existing concepts. You have to perform this for patents as well as for non-patent literature. Then you have to ascertain that your idea or your invention is totally different from the prior art. The green part is the existing existing field or the prior art. This is how you have come up with an idea which is totally different, or it has lot of differences with the existing prior art. If you can make out this, then half of the job is done towards the patenting activity. So therefore, research is to see what everybody else has seen and to think what nobody else has thought. Ideas are very common, but however, inventions are very rare because inventions need special efforts. Therefore, always wisdom lies not in the amount of knowledge acquired, but in the degrees of its application. This is very, very essential. I will tell you one example here. Look at the Japanese standard. In 1900, they were not really a very developed nation or very strong nation. We have looked about us to see what nations are the greatest so that we can be like them. We said, what is it that makes the United States such a great nation? And found that it was patents. And so we will have patents. He is the general of US Patent Office. He visited United States. Then he thought, why US is so great? Why can't we become like US? We also want to become great like US. They found it is patents. So then they started doing patents. Now we all know what is the stand of Japan at a global level. But however, there is a good growth in number of patent contributions or IP contributions from Indian side also. This is some of the statistics. And very recently, Prime Minister has told from like in the Indian Science Congress My motto for the young scientists in this country has been innovate, patent, produce, and prosper. These 4 steps will lead our country towards faster development. That means a prime minister of the country is also asking people or the scientific community to contribute towards this. That means you can find, you can realize the importance. Not only our prime minister, look at the US, though it is already a strong nation, but always they try to maintain, or they want to their sustenance. Innovation has been essential to our prosperity in the past, and it will be essential to our prosperity in the future. That is what the continuous efforts are required to maintain that stand. It is estimated in a decade or so, as much as 90% of the value of the world's top 200 enterprises will consist of intellectual property. That means, is this the real? Is it real? Yes. Does the intangible assets have so much value? Yes, it is true. Why? Because whatever we see in the market today, each and every aspect is, each and every object or each and every process or technology, each and every of these things have IP concept with them, either in the form of patents or in any others. But in spite of knowing all these things, even as on today, the very generic scenario in Indian society or community is this. All I asked was, can I patent my copyrighted trademark? Look at this cartoon. So this is because, it is because we don't have a very systematic learning or systematic practice of IP. That is the problem. So therefore, when one should go for a patent, whenever the preliminary workability of idea is done, and it should be always before publication, and it can be helpful for gaining competitive edge over the similar technologies. And also, if you feel that you want to license it to someone, before licensing, before doing any of these things, you have to go for filing a patent. But however, the global average of success of patents is only about 2%. If you have 100 patents, out of those 100, if 1 or 2 patents are commercialized, attracts money, that means you are on par with the global average. Now from here, I will try to look into some of the insights into filing and processing with respect to the fees and other supporting sources for academic institutions. This is the patent history in India. This is the first patent from India in the year 1856. These are the timelines. The day when you file a patent application, that is called as the filing date or priority date. After 18 months, it will be published. Within 24 months, it has to be granted, but however, it takes more time, and the patent will be valid for 20 years. The time from the day of filing to the day of grant is called, can be categorized as office action, because during these times, patent office role will be there, and patents can be challenged anytime by opposition from the day of publication to the date of expiry. And this is the front page of the very first Indian patent granted, Indian patent. Facsimile of the first specification and drawing for grant of exclusive privilege in India. The first page, he is the person. Penning and Depenning is the company now. It is a very big company. They're still, the company is working as on today. This is a complete patent filing process. It is a very generic process. Hope you might be knowing it, but however, I will explain it to you in a very quick manner. Patent filing, you can go for a provisional as well as for a complete. Provisional is possible if you feel that your idea is there, but you did not work out fully. So therefore, you want to gain some advantage. It is like advanced reservation with no confirmation. It is like a provisional specification. But however, within 1 year, you have to file a complete specification. Otherwise, it will not be of any value. Once you file the complete specification, then it goes for pre-grant publication after 18 months, followed by it will be examined, provided if you file a request for examination. After that, you will get the first examination report. Sometimes, if there are no objections, your patent may directly be granted. Later on, post-grant publication will be there. If someone wants to oppose, they can oppose, and opposition proceedings may happen. Based on that, either your patent may be accepted or it may be revoked. But however, most of the Indian cases, they face objections by the examiner during the first examination report. This is quite possible in more than 99% of the cases. Even in my cases, in our cases also, many of our patents have got objections raised by the examiner during FER, first examination report. But however, we can defend those objections, file the reply to the objections, and they will consider for the re-examination. Based on that, sometimes they may call us for hearing. Based on successful satisfaction, either they may reject or they may accept. If our defending is convincing and proving, then our patent will be accepted. If not, it will be rejected. So this is the brief outline of patent filing process. And look at this. Here I try to show you all these activities with a time-bound manner. Filing, then after 18 months, the publication. But however, sometimes we may feel that, sir, my patent, my work has a lot of potential. Already companies are approaching me. I cannot wait for 18 months until it gets published. So is there any way? Yes, it is quite possible to go for an early publication. There is some additional fees that you have to pay so that within 1 month your patent can be published. After publication, within 1 month it can be examined, and within 6 months there is a possibility to get the grant of your patent. Otherwise, the regular mode is filing followed by publication. Then from the day of filing to the 48 months, you can file the request for examination. Then it will be examined followed by first examination report. Sometimes after publication, you may face opposition also. That is called as pre-grant opposition. Again, that is several steps. Again, hearing will be there, decision can be taken. After first examination report, based on the response you submit, the same thing, hearing, granting, grant notification. Then if they go for oppositions, again appeal, refusing and granting, all these are very regular activities that will be taking place at the level of patent office. But however, all these aspects can be completed within 12 months. But effectively we can make it provided if we are ready with all the answers for the objections raised by the patent office or the objections raised by the opposition. So therefore, to face any of these things, we should be very strong and we should be very supported with all our documentary evidences. Documentary evidence is very, very important in any of these patenting activities. Now look at these fees. I think this is very, very important for all the researchers, because there is a misconception that patent filing activity is a very expensive activity. But in reality, it is not so. If you want to file patent by your own, you can do it. Otherwise, you can take help from some professional experts. But however, taking support from professional expert is an optional category. That is the reason why I put them in optional category. There are some regular fees that have to be paid at the patent office. This is 1,600, 4,000 and 8,000 depending upon the type of category you belong. There are 3 categories. One is natural person like individual. Second one is small entity. Small entity means MSME, startups and these things. Third one is large entity, generally universities, organizations, big companies, all others. So for that, the fees will be 8,000 for electronic filing. And if you go manually, 10% additional charge will be there. And if you want to publish your work very early, you can go for this request for early publication for high potential inventions, for which as you may have to pay another 12,500 as extra fees, so that within 1 month your patent application will be published. And again, request for examination fees for individuals it will be 4,000, for small entities or startups it will be 10,000, for others it will be 20,000. So this 20,000 here, this 8,000 here, put together 28,000 is the regular fees payable at the patent office. If you are going through your university or a college or organization, suppose there are many cases where the organization allows individual to go and file a patent initially. Later on, if that patent attracts a lot of commercial value, you can transfer ownership from your you can transfer your ownership from individual to the organization. That is also quite possible. Anna University, for example, is practicing in the similar way. Even there are many private universities like Amity University, Lovely Professional University. They try to they are filing huge number of patents, but it is by individual names only. When they attract some commercial importance, then the ownership will be changed because of this money or fees factors. And all other fees are like optional fees. For the professional charges, one has to utilize. And this is fee in detail. I think if you go as an individual, patent filing fee is 1,600, filing for request for examination is 4,000. So put together 5,600. With about 6,000 rupees, you can very well file a patent application. But however, patent drafting, searching for patentability, all these things are at your risk. You have to perform by your own. If you take any help from professional agency, they may charge accordingly. But if you are a large entity, if you are filing through organization, then the fees will be about 28,000. So there is no much difference, and it is not too expensive. In case if you have a potential invention, even for an organization also. But for an individual, whatever number of patents you want, you can file, because hardly 6,000. It doesn't matter. Tomorrow, who knows? Your invention may lead to a blockbuster technology. So therefore, for filing, you have two options. For publication also, you have early and normal. Even for examination also, you have expedite and normal examination process. If you go by normal mode, that will cost about 30,000 to 50,000 for an academic institute or organization. If you go by early mode or expedite method, it will cost extra 10 to 20,000, but the time period will be very, very small. This is how I can compare these things, normal filing and fast track filing. The total time period is minimum of 26 months. But however, in reality, it is taking about 48 to 50 months. But if you go by fast track mode, it will happen within 6 months to 1 year for sure. Because everywhere, all these formalities are completed in 1 or 2 months time frame. And this is about international application process. I don't spend much time here. This is Paris Convention route. File today, within 12 months, you have a time period to go into other countries. There's another way called as PCT. File today, and you will get 30 months time period to decide in what countries you want to go and apply. And meanwhile, you'll also get a lot of benefits like international search report and also international preliminary examination report and all these things. But however, PCT filing is an expensive process. This is the average cost and time to file and grant a patent in different countries. In US, it takes about 10 lakhs, 2 to 4 years. This is the money for complete 20-year terms from the filing to the 20 years, because you have to pay maintenance fees also every year, including all expenses. This is the cost. 10 lakhs for US, Singapore about 8 lakhs, India it costs about 4 to 5 lakhs, Europe also 6 to 10 lakhs. This is the time. Now these are some of the agencies in India which will give financial assistance to the research institutions, academic institutions, and also individuals in patent filing aspects. There's an agency called as National Research Development Corporation. Even I was also part of this company for about this organization for about 8 months during 2016-17. I worked as a manager there. And if you go into the programs here, you will go to the Intellectual Property Management tab. There you will find NRDC Intellectual Property Management Division assists in following services: National Patent Protection Scheme, patent search facility, assistance in commercializing patented inventions, and all these things. So here what do they do is, there is an application, you have to fill and apply for that. Based on, they will scrutiny your application. Based on that, they will give you financial assistance. All the fees related to the patent filing, patent examination, patent searching, patent drafting, all professional fees, everything, they will only take care. And this, we have, when I was working in NRDC, I was also directly involved in supporting SV University. There's a professor named Professor Suresh Reddy. They had an invention but they were unable to find out funding. So they have approached us. We have supported through NRDC. It costed about more than 1,20,000. Even then, all expenses were supported by NRDC. So this is one way. The second one is there's another organization called as TIFAC under Department of Science and Technology. They will also support innovations under different categories. And there are also patent facilitation centers. All these will help academic institutions, individuals, startups, and any other organizations in these activities. There's also another agency called as CPAM, which will also help in assisting the IPs created by individuals, organizations. So these are the three major agencies which will directly support the IPs. But always we have a fear of failure. This is where individual limit starts. But however, to come across this, we have to look into these 2-3 slides. He is a person who has invented his own product. He thought it will act as a parachute. He tried to test it by jumping from Eiffel Tower, by wearing it. When he does, he died. So finally, the end result of his invention is his death. But however, we should appreciate him taking such a big risk because he has to prove his invention. So he has taken that risk. So therefore, to make a very good invention, we have to take risk. But always risk need not be of that level. But however, in India, the major concerns are there is a big lack of teamwork and there's a big lack in producing the recordable data. Without data, you are just another person with an opinion. So therefore, documentary evidence is very, very important. Recorder of all the data related to our inventions are very, very important. And always risk drives innovation. I think this I will skip. See this, ring pull cans. The inventor got about 148,000 UK pounds per day on royalties. This is the power of invention. A simple idea then led to the development of this product and they have patented it. After that, they did not work on that one. They sold it to someone. For that, 148,000 UK pounds per day on royalties. So this is the power. Look at this. He is the youngest patent holder from India. Hridayeshwar Singh Bhati. At the age of 9, he was granted a patent for 6 variant player of the chess. Even the Michael Jackson, for his dancing pattern, he has a patent. So that is how that is the reason why US is always called as a strong nation, powerful country in the world. Look at this. The patent system added the fuel of interest to the fire of genius by Lincoln. This is, if you enter the US patent office, on the front, it is there. At the entrance of your US office. Even the Abraham Lincoln, he himself got a patent. Manner of buying vessels, US 6469 is the patent, which was granted to Abraham Lincoln on May 22, 1849. And even the Tata Nano has got about more than 40 patents. So therefore, this is how one has to convert ideas, then ideas to workable ideas, then work on them properly, prove them efficient, prove them for their effectiveness and protect them in the form of patents. And finally, try to get some benefit out of your protected inventions. So from here, within about 5 or 6 minutes, I'll show you some of the case studies related to our contributions towards the potential inventions. Because as a researcher, until I completed my PhD, I was not having any idea about patents or inventions or commercialization. I was just doing this. This was my basic research, to design some catalyst, do their testing, show their effectiveness, and put them in some publications. And if possible, go for high impact publications. But later on, knowingly or unknowingly, I entered into IP field. I had to work with an IP company where I started learning about what is called IP, what are the different factors, aspects, different kinds, what are the search methods, what are the search platforms, what is chemical searching, what is biology searching, what is this one sequence searching for nucleotides, peptides, all these things. So on different aspects, I worked for about 2 years, from where I could learn all these factors. And later on, I thought as a researcher, I should explore the research activity as well as IP activity parallelly in hand to hand. And then from there, I started my journey of combining research and IP together, leading to effective research results, from which the right hand side part is mostly because of the combined efforts from research as well as IP. We could able to file 22 patents, out of which 5 are granted, others are in pipeline, and very recently one of our patent was licensed to Sun Pharma. I'll show you some of those slides. This is a very, very good example of how an idea can lead to development followed by patenting. We found, as a researcher, we thought as an organic chemist, we should contribute to something which will bring in a very big difference in our research group and in our institute. And as an organic chemist, we thought we should go for developing some new processes. And it took about 2-3 months to identify which process we should develop. Finally, all these projects or all these works I have involved personally with my IP experience. I found after rigorous patent search that lipoic acid is one of the approved drug molecule which is required in day-to-day aspects as well as for the treatment of diabetes. But however, in India, no company is making lipoic acid. But India imports 410 tons per year, 96% from China, 4% from US. It's about cost of $43.6 million US. Now, we know the problem. Now we started generating some ideas, thinking, doing literature search, patents, publications, everything. When we conducted prior art searches, I found so many patents on lipoic acid. Then how do we make a different one? I found it very difficult to come up with a new process. But later on, with systematic examination, we could able to come up with an improved process. It is not new, but improved. So when improvement is there, certainly it attracts. It becomes eligible for a patentable invention. Then we started working. And when we started working, it took a lot of time to optimize the results. Then when we got our first optimized result, we thought we should go for process validity, scalability on one side. At the same time, we should also plan for filing a patent. And in any of these drug molecules, always the product should match with USP standards. On one side, research and development activities was going on. On the other side, patent drafting, patent searching, and patent filing process activity was started. Finally, we could able to file the complete specification in the year 2018. We started in 2013. Idea came into our mind in 2013, but we filed patent in 2018. It took about 4 to 5 years for us to generate ideas, work on it systematically, then put it into proper practice, then take all the recorded evidences, prove it, scalability, everything, then go for patent. When we got the patent, we started showing up this work to all the industries. And very recently, we could able to attract one industry from Bengaluru, who will be making this molecule. So therefore, finally, we call it as a start and end protocol, which is an improved version, and we have technology with us. And this is the complete process of lipoic acid. The known process, but there is a big improvement. The improvement is we have performed this only using single solvent, but all existing works were using more than 2 or 3 solvents. But we could able to do it in one solvent. We could able to develop both batch as well as continuous process for this. And these are some of the other examples. Nimbolide is a natural product for which we could able to develop analogs, and we are studying their anti-cancer properties. It is all these collaborative works. The other one is nicotine process. Nicotine, we all know it is present in tobacco here and there at many places. Addiction to nicotine is very, very harmful. But however, it is very difficult to make addiction nicotine-free society. Then we thought, what are there any alternate possibilities? Then we found if we convert all the hydrogens on nicotine into deuterium, that will become a safe nicotine. You can use it in any manner, it will become safe. Before that, we thought, is it possible to develop a process for nicotine? Why? Because any nicotine available from natural sources always contained impurities, unseparable impurities. So therefore, it is always to have a pure nicotine in our hand. When we perform the search, I have come across more than 200 patents. Then we thought it is very difficult. Then when we analyzed them very systematically, all the process were about 8 steps or 10 steps or 12 steps. We thought, why can't we come up with a short synthetic route? Then we could able to come up with this process by using streaker synthesis. In 4 steps, we could able to synthesize nicotine in purest form, both stepwise manner as well as in one-pot manner. We got 4 patents for this, and very recently this may also get commercialized. And this is another work on TPP coupled escalatin for anti-atherosclerotic effect. It is a combined work of chemistry and biology group. It is my first patent in 2015, and it took about 2 years to draft this patent because it was my first experience. But very luckily, in 2019, the same patent was licensed to Sun Pharma. And in 2018, IACT has got about 5 crores as royalty for first milestone payment. If everything leads to success, means we may get about 50 to 200 crores, anywhere between 50 to 200 crores. So that is the benefit. But when we started working on this project, we were not sure. We were not even planning for patent. We thought we'll just make a work, we'll go for publication. If possible, go for very high impact publication so that we can showcase here and there. That was the only aim. But after having IP knowledge, we could able to convert it into patent. Because it is a patent, it got licensed to Sun Pharma. Otherwise, in similar manner, we have published so many works, but none of them we could convert them into technologies or licensed technologies because they were not having any patent. They are available for free. Because this is a patent, we could attract money. So this is one of our success story in converting our research idea to a research development program, then converting into a patent followed by its license. Since out of 22 patents, 4 of our patents got licensed, we are on par with the global average. That is what we can justify. This is the patent for nicotine. This is a complete process. And this is the patent of the one molecule which was licensed to Sun Pharma, a US patent which was granted in the year 2017. But however, for the same work, Indian patent was granted very recently in May 2020. This is the molecule. This is the molecule. This is the steps. So in 4 steps, we could able to make up this and followed by biological activity. And these are the first pages of US patents for this anti-atherosclerotic molecule as well as this nicotine process. These are the other collaborative works. There's pyroxindole compounds which are useful as GSK3B inhibitors. These are indole sulfamyl derivatives for HDOC inhibition. For all these activities, the efforts were like this. Initially, we thought to identify the white space, patentable space. We thought in case of HDOC inhibitors, we found there are many molecules, but however, finding a selective HDOC inhibition activity, compound with selective HDOC inhibition activity is very, very rare. Then we focused on that, we could able to get some patents. Similarly for spiroxyindoles, similarly for others also. So this is the complete process. I think this is more into chemistry. This is HDOC inhibition selectivity. Because for designing of all these chemical molecules, we need the knowledge of organic chemistry and also medicinal chemistry. Then these are the patents. See, this is a PCT application. This is the chemical structure. This is the chemical structure followed by biological activity. This is for spiroxyindoles, right side one. The left side one is for HDOC inhibition. For all this, we got patents. And this is another molecule, zafurlic acid, which is an approved drug molecule for the treatment of asthma. And we found no inventor, no patented route is a short route. All are using more than 10-step process. Then we thought by using multi-component synthesis approach or organometallic chemistry approach, why can't we develop a short synthesis for this? Based on that, we could able to develop a 5-step synthetic protocol for zafurlic acid and related molecules. Now we are in negotiations with many pharma industries, because this process will provide an alternate route for making of this drug molecule. If it gets successful at a production level, means the production cost for all these pharma industries will reduce by at least 50%. So this is the Nimbolide. These are the derivatives that we have synthesized, and this is the patent for Nimbolide, US patent. This is for the other one, Zafurlukast, the molecule for asthma treatment. So this is another compound which we have performed with IICB collaboration. It's again a chemical biology work. So therefore, always we could able to lead to success in converting ideas to research development to patents. It is because we have knowledge. Of course, we all have knowledge. Also, we also have experience. But however, we should also try to add some creativity to that. And if we can able to connect knowledge, experience, and creativity, then we can certainly go for effective contributions leading to effective IP outcome. Therefore, promote, protect, and profit. This should be our slogan for IP. And always for that, we need to have awareness, understanding. Then we should think for contributing. And many of us still, even as on today, if you ask me, even I suffer with this. Oh, first draft, it is very difficult. It takes time. I don't know how to do it. No, it is not coming. It is very difficult. All these things we feel. But however, for an organized performance, first drafts done have to be perfect. They just have, first drafts don't have to be perfect. They just have to be written. But always what we feel is whatever we start, we should start making it perfect. No, that is not the case. First, you try to start drafting your patent application, patent specification, whatever you have, you just put them into the draft. Call it as a first draft. Then you feel some kind of belongingness. You feel that, okay, I started contributing to or writing a patent. Then let me fine-tune it further, then bring it to a proper shape. So therefore, it is my humble submission that always try to make your first draft by yourself. First draft need not be perfect, but it has to be made. Then IP is very important because future wars will not be fought over territories. But it will definitely, future wars will be on ownership and exploitation of ideas. So therefore, ideas are very, very important. We might have seen many wars, many fightings between Apple, Samsung, and many others. So therefore, idea, potential idea, patentable idea, these are very, very important features. And if we are doing this, formulate hypothesis, accumulate data, do extensive testing. I think we all are doing this. Yes or no? I think we all are doing this. If it is true, then this is the old way. So therefore, what we need to do, formulate a hypothesis, patent it, raise some $1 million. 17, I put some number, but it can be any number. This is the new way. So therefore, IP has big power. If we can divert our research trends towards this, certainly we can contribute to effective IPs. So therefore, once again, I am trying to end up my presentation with this slide. Innovation distinguishes between a leader and a follower. We were being followers for these days, but from now, at least from now, we should think to become leaders. So therefore, we have to start generating ideas, because everything starts with an idea. So generate ideas, become the leaders. And I try to make this presentation on these different grounds. It should be informative, impressive, effective, depictive, interactive. Of course, interactive means we have to discuss. Seeing is believing. And sometimes some cartoons I have used. I don't know to what extent I have justified, but I try to put efforts in making presentation with these baselines. So with this, I thank you all for your patient hearing. Stay safe, stay home, keep connected, and be productive. Thank you all. If you have any queries, we can take up. I think I was little lengthy, but I think it's okay.
Thank you so much, Dr. Pawan Kumar, for your detailed informations in patenting in different fields. Definitely, this webinar will help our participants to get an idea to convert the novel research ideas to patent in the future. Now we are moving to the Q&A. Sir, can I start with the
Yes, yes.
questions? Okay.
Yes, ma'am, you can.
Okay. So what is the meaning of patent abandoned? One of the participant was asked.
Patent abandoned. What happens is, when you file a patent, after its granting or even before granting also, we need to follow up with the different activities, because many people feel that patent activity is a one-time activity. We go and file our application, that's all. It is not like that. During the process of patenting activity, if you fail to pay the maintenance fees, or if you fail to file the request for first examination, in those cases your patent gets abandoned. Sometimes the same can also be termed as lapsed. Okay.
Okay, sir. Next question. Is it possible to patent medicinal applications of bioactive molecules isolated from medicinal plants?
It is possible if you isolate some molecule first, and if the molecule isolated is new, you can very well patent. Otherwise, you can generate some analogs of the isolated molecule. You can patent those analogs along with your parent molecule. And I have shown you one example in my studies also, nimbolide. Nimbolide is a natural product isolated from the plant. But however, the original person who has isolated that, he has already got the patent. What we did is, we have developed the analogs over this base molecule. Then we have filed a patent for these analogs as well as for their biological activities. It is quite possible. Hope you got my answer.
Thank you, sir. Next question is there any special monetary funds given by the government that one can get with research and patent? It will lead to patent.
Pardon, can you please repeat the question?
Is there any special monetary funds given by government with the fund?
Is there any monetary fund given, special fund given by the government? As such, no. But however, the agencies like NRDC or even if you are writing any research proposals, now you can include a component for patent expenses. Like you give the funding breakup, budget breakup for contingencies like that. You can say that for patent activities, you can give some breakup for the budget. They will agree. And there are some funding for potential inventions like awards. There are some schemes you have to apply for them after getting your patent or after getting your technology. But as such, just for a researcher or just for an organization directly, I don't think they will give.
Okay, sir.
Okay.
Next question. Do patents expire?
Yes, patents will expire after 20 years. In general aspect, patent term is valid. Patents are valid for 20 years, and after 20 years, automatically they will expire. Even before 20 years also, if the inventor or the owner fails to pay the maintenance fees, then certainly they will expire and they will come into the open domain. And if you try to search in these some of the paid databases, they have two tabs. One is active patents, the other one is dead patents. Dead patents are patents which are expired. The reason of this expiry may be completion of the term or non-payment of the maintenance fees or any other reason.
Thank you, sir.
Okay, hope. Okay.
I think the next question maybe you have already covered in the presentation. Why researchers prefer publication over patent? Any comments you wanted to add, sir, with that?
Very good question. why researchers prefer publications over patent. First thing is, many of the researchers, they don't have a proper awareness and understanding of patents. Second thing is, they feel that patenting activity is a very complex activity by way of time and by way of money. These two things. Third thing is, any researcher expects a very quick or spontaneous visibility or credit. Your publication means if you submit the publication within 3 weeks or 4 weeks, you get the result of its acceptance and it will appear online. Patent is not like that. But however, even in case of patents also, those things are possible. But even then, that kind of awareness is still missing. Maybe this is the only reason.
Okay, sir. Thank you. Next question, that is the last question.
Okay.
In your presentation, you have told microorganisms we can patent.
Yes.
Is it possible that nutrients required for the growth of microorganism can be applied for patenting?
Nutrients required for the microorganisms?
Growth of microorganisms.
Okay. See, nutrients required for the growth of microorganisms. See, here generally it is little tricky, because microorganisms means if you are doing any inventions related to microorganisms, you have to deposit that microorganism in a international depository. Well, there is 2 depositories, one at NCCS Pune, the other one is at Intech Chandigarh. Then you can perform. But nutrients required to growth of microorganisms, I don't know exactly. But however, you need to mention about this information. That is for sure.
Okay, sir. One more question. The inventor renew his patent after 20 years. Is it required, or any problem is there for renewal of the patent?
No. Renewal of patent is, the concept of renewal of patent is not at all there. Renewal is not at all possible. The patent term is only for 20 years. After that, if you put your head down and leg up also, no renewal is possible. Neither PM nor President, no one will help in renewal. The last
Hello, sir. Sir? Pavan, sir? Can you hear me? Your sound is not audible. Sir, please unmute.
Yeah. Hello, is it okay?
Yeah. Now we can hear you, sir.
So patent renewal, the concept of patent renewal itself is not there. So therefore, don't think about renewal of patent.
Okay, sir. Thank you. That was the last question. We are moving to the end of the program.
Okay.
On behalf of the organizing committee, I take this opportunity to propose vote of thanks to those who have directly or indirectly contributed to this webinar on research ideas to development and patenting, an academic perspective with case studies. At the outset, I thank our resource person, Dr. Togapur Pavan Kumar, Senior Scientist, CSIR Institute of Minerals and Materials Technology, Bhubaneswar. We are really enlightened with your knowledge and presence and your detailed explanation about the patenting. Thank you so much, sir, for accepting our invitation. We are thankful to Dr. T. Somashekar, Chairman, Indian Academy Education Trust, and Mrs. T. Bharati, Secretary, Indian Academy Education Trust, for their constant support and encouragement to organize this webinar. I express our sincere gratitude to Dr. Srinidhi K. Parthasarathi, Chief Operating Officer, Indian Academic Group of Institutions, for his motivation to organize this program. I would like to thank our beloved principal, Dr. E. Jerome Xavier, Indian Academy Degree College Autonomous, for the constant support and inspiration to organize this national webinar. I thank Professor Shalini S, Vice Principal, heads of various departments, and faculty members for their presence. I express my gratitude to all the participants from IADCA and other prestigious institutions for your patient listening and cooperation to conduct this webinar effectively. I sincerely thank all my colleagues for their support to organize this webinar successfully. I would like to thank Mr. Chandan Rao, IT Manager, Indian Academic Group of Institutions, for his technical support.